Hi, Jackie. This is Greg Perniuk.
Hi.
Hi. I was wondering if I could talk to you about a few topics from the meeting from last week.
Okay.
Okay. First of all, would it be possible for you to call me back just because I'm concerned about using up a lot of my cell phone minutes?
Sure, no problem.
Okay.
What was your number?
780-707-4658.
Okay.
All
I'll
right.
give you a call back.
Sure, thank you.
Sure.
Okay, bye. Hi.
Hi. It's Jackie calling back.
Hi. So, well, thanks for calling me back. And so the first thing is, before the meeting, like not at the office but on the phone, I told you that I was concerned about there being a conflict with Jeremy Taylor representing the chief in my lawsuit and with the LERB appeal.
Okay.
And like I guess I kind of forgot to bring up that point. I know that you suggested that I bring it up like right at the beginning of the meeting, but I forgot to bring it up.
Okay.
Even though obviously Mr. Smith, like I have to presume that you informed him of the lawsuit, and that's why he brought up the lawsuit at the beginning of the meeting.
Right.
And so like I've now received other statements of defense from Joseph Faraka, which shows that he's defending the other defendants, including the 3 members that are involved in the LERB appeal.
Right.
So I was just like, I still think this is really problematic and some type of a conflict, and I'm concerned that all of the information that I've given so far in my appeal documents, can and will be used by them to form defenses for my lawsuit, and therefore that they can plan defenses based on my information.
Well, they're under an implied undertaking as you are, right?
Right.
So there's an implied undertaking with the documents provided in this proceeding.
And that means that they can't plan defenses based on my information?
They can't be used in other proceedings. Like you can't use the record in other proceedings.
Right. So they can't use like beyond the record, like my appeal documents, like are those technically part of the record now that I've included them? Like is
they're
that
part of our record?
Right. So does that mean that they're, part of the record and therefore off limits to both them and to both me?
Right.
Okay. So would I be able to? Because I still think that it's a problem or a conflict of like it just feels wrong to me. So would I be able to tell the board what I think about this and that I think it's a conflict and ask them like to give me an opinion in writing about whether they think it's a problem or a conflict?
You can put your concern in writing and I can give it to them. Sure.
Okay. Just because I just would like an actual opinion on that. And so just out of curiosity, like I read a bit on the LERB website where like the board is kind of like a quasi-judicial, like that's what it says on the website. Does that mean that they're lawyers or are they not lawyers?
Some board members are lawyers. The board chair has to be a member in good standing with the Law Society. And on every appeal there is at least one lawyer just because they are the ones who write the decisions.
Right.
Because they are quasi-judicial.
Right. So in other words, if I present this concern, they can give me basically a legal opinion.
Well, I don't know if they go so far as to give a legal opinion. They can give the board's position.
Right. Okay. I guess that would be. I mean, basically, I don't know. I just feel like I have to raise this point just because it bothers me. But anyway, so. Well, I mean, it's not because it bothers me. It's because I think, I don't know, I have an extreme mistrust of the people involved, both the, EPS, the PSB, and the lawyers due to this whole thing and all the issues that I've raised so far, and that's why I'm concerned about this. So you're saying if I, send an email just to the LERB address, I could,
Yeah.
Okay.
We'll pass that on to well, likely Mr. Smith. He's presiding right now, and he's a lawyer.
Right. Okay. And as you know, obviously, Mr. Smith at the meeting brought up that I can't use information from the record without asking permission. And so, is that something that if I was going to do that, would I need to do that, basically as soon as possible, or is that something that I would ask when the LERB appeal is done, which would be when all information has been gathered?
Well, it would depend when you wish to. I guess generally you ask permission when you intend to use it in another proceeding.
Right. Because, obviously I've filed my statement of claim and I've received statements of defense. So, obviously I would want to use this information, as part of, further, obviously I've never done this before, so I don't know, but, I'd want to use it later, but I just don't know if that's something I would, apply for now or when everything is done. I guess I just don't know.
Right.
Go on.
I guess it's up to you when you would apply for it or when you would make your request. I wouldn't really be able to tell you when would be the best time. It's up to you. If you intend to make the request, then I guess there's no point in waiting. But you're not limited to a time period.
Right. I guess I was just kind of wondering whether, in other words, if I made an application now to use the record, does that mean I can only use the actual PDF record, or can I use information that I have to believe I can use information from my own applications or my own documents that I've submitted so far.
Right, those are yours. Yeah. It's the record that was prepared for the purpose of the appeal.
Right, I see. So the documents that I have that I've prepared, but I guess they rely on the record.
Anything you've obtained through FOIP is not part of the record, right? So.
Right. And I guess obviously since the documents that I've given you so far, the additional grounds and the applications, those obviously rely on information from the record, so it's kind of
right.
It's all tied together.
It's all tied together, yeah.
And so I guess if I made an application to use the record for this purpose, would that, does the quote-unquote record include when we go to this hearing and the results of this hearing?
Yeah.
Okay, so I see. So it covers everything, and that's why I was wondering, if I made this application for the record now, it would include whatever comes up later.
Right.
It's not just what has been made available to me up until this point. Okay, so it covers everything.
Yeah.
Okay, so now. Having now received the statement of defense from both of these lawyers, I believe that they have used material from the record, based on what they've said in their statement of defense. So are they allowed to do that with permission or without permission, or is it only, they have to get permission too, don't they?
Right, although I have no way of knowing because we don't see anything that has to do with the civil suit. We only see, so I have no idea of knowing.
Right.
I have no way of knowing what they've used.
Right, exactly. Well, I'm just to be a little bit more clear about that, because obviously, this is obviously the first that you've heard of this, but in my complaint package, I included documents from Alberta Health Services, the crisis response team, because they responded on the night that I was assaulted, and so these were supporting documents that were from AHS that I obtained straight from them, and they were in the supporting documents folder, and they were footnoted and referred to and all that, and so they were in fact printed into the record, and therefore, as far as I know, these documents wouldn't exist to the lawyers except in the record, and so.
Are those in the record?
Yes, they are.
Okay.
And so that's just it, is that they wouldn't exist to the lawyers except in the record. In other words, they're part of my complaint package, and they're in the record, and the lawyers would have no, I mean, unless they somehow prove that they got these from AHS themselves, but they're like specifically referring to these documents in their statements of defense.
I wouldn't be able to. I don't know.
I guess, and obviously I appreciate that you don't personally have an answer to that question, and that's why I was wondering if I could submit a question to, again, to the board through the LERB address, and obviously not CC'd to the lawyers about this, this really, it blows my mind that everything, like, I keep thinking I will never be surprised by the information that I get from all of this story, these events, but this just amazes me that they're referring to Alberta Health Services documents regarding my depression, basically, right? Because these people were responding, and that's what they talk about, and that they're using that as part of their statement of defense, and that, as far as I know, they'd only have access to that information in the record that is, that you have and that I gave to them, right? So it's astoundingly unethical, in my opinion, and I'd like to be able to ask the board whether they can, in fact, use this information if it was only included in my complaint, and therefore that's the only way they would have access to it.
You could ask the question. I would be prepared that we may have to go to the parties and ask them.
Right.
Because we have no way of knowing, and we have very limited ability to overstep, so to even consider what's going on in another jurisdiction. So you could ask, but very likely we would have to go to the lawyers and ask for an explanation.
Right. And is it okay if I actually give you copies of those statements of defense? Is that out of bounds on my side?
Well, we would have no reason to look at them. You could say that you could provide them if necessary, I guess.
Right, because obviously that would tell you exactly what I'm talking about, and obviously I can point to the actual pages in the record that are those documents, right? Because you have that information, so there's obviously a way for you to cross-reference this if I give you their statements of defense, and just to be clear, I don't. It's not like they're not responding to a point in my statement of claim with this statement of defense. In other words, I don't refer to those documents in my statement of claim, but they've brought them up in their statement of defense. So, in my opinion, this is astounding, and then that's why I would like the board to be aware of this and to, because, and correct me if I'm wrong, they haven't, the lawyers have not asked to use the record information. They haven't made that.
I don't believe so. We are so rarely asked for implied undertaking to be listed.
Right. So that's basically it. Is that, and obviously, like I say, I'm not expecting you to have the answer to this question, and that's why I'd like to put this in writing. And because, as far as I know, that's the only way these lawyers would have access to this information. So who knows whether they've found a loophole somewhere that allowed them to get this information, or I don't know. Obviously, and that's so I guess that's all I'm wondering is whether I can just basically write that up and ask what the board's opinion about this is.
I don't know what our answer would be, but you could ask.
Right. And that's just it, right? This is, well, obviously I have no idea. So what would happen from a legal standpoint. But so basically I guess that's two kind of questions I would like to raise to the board. Should I put those in separate emails or?
Sure.
Okay, just so that it's straight. Okay, and so I don't know whether you can ask this or answer this, but because this is another thing that just boggles my mind, and I don't know how this works, but there's two lawyers at two different law firms. Are they allowed to collude both on a defense for this appeal and a defense in my lawsuit?
I don't believe it's uncommon. They're representing their clients, right?
Right, and I guess I don't know. I guess I'm surprised because if they were, Like it just so happens that one of them is the chief of the police and the other are members of the police, but I don't know, just seems like, are they actually allowed to work together, I guess? Like
well, they don't work together, they represent their clients. So they both have the same clients in different jurisdictional matters, right?
Right. But I mean, like but are they allowed to like work together basically? Like, I mean, maybe
I don't know if they're working together. All I know is that they're representing their clients and they're a common client.
Right. Well, I mean, I guess the thing is that the statements of defense, so I received a statement of defense from Taylor at Field Law for the chief, and then I received a statement, well, actually I received two separate statements of defense for the other members from Farraco at Weir Bowen, and the vast majority of those two statements of defense are identical, as in like copy and paste identical. So that's why I wonder whether they're actually allowed to work together on this. It's weird.
I don't know.
Right.
I don't know. I'm not the Law Society, so I don't know what the rules are specifically.
Right. Do you think that could be a question I could ask to the board?
I don't even think the board would be able to provide an answer. You could ask the Law Society of Alberta.
Okay. Because I think, well, I'm glad you brought that up because that sounds like a good resource for that type of a question. Or I guess, well, yeah, I guess, or even, I mean, I'm going to be meeting with the Edmonton Community Legal Center. Like you've probably heard of them, right? So
you could speak to them and ask them.
Right, because it would be an actual lawyer who could
Right.
give a legal opinion.
Right.
Right. Okay. Well, so I think that's what I think that covers everything that I was wanting to ask you about. So yeah. So I guess. Okay. Well, I appreciate your time, and I guess that's everything for now.
Okay.
All right. Thank you.
Okay.
Good. Okay. Bye.